Hello, everybody. I'm glad to welcome you this second day of our conference. And as Sasha has said, we're starting from the Q&A session that is dedicated to special tribunal for the crime of aggression, and Anton Korynevych is going to answer the questions. He is the director of the Department of International Law, the Ministry of Foreign Affairs. And first of all, I would like to thank you for finding the possibility to be a part of this International Criminal Justice Week that we're holding every year. And second of all, I would like to just make an introduction by saying that the process of creating the tribunal is already on the finish line, and it's like we're moving to the first place stand on the finish line, finish stretch, and that's the sports analogy. And I want to thank everyone who has contributed and who will be taking part in this process for making all these things real, for the hard work that is behind all this. And I would like to allow some sort of personal remark on my personal behalf. I will take just a little bit of your time. Since we made our acquaintance, I'm captivated by your cold-blooded style, by your stand, and because we had deliberations on the legislation on the national criminal law, and like from minute 30, when even 40 minutes, I'm starting to get incensed, and then he's all calm and placid and all, and you're because I remember that you were talking so emotionally once about those problems that were part of the process of creating the tribunal, and I was like, if he is responding like that, and everything is so complicated, maybe things going bad, and there will be no tribunal. And just to be sure, I wasn't 100% sure. And then when something like that has happened, it's like a legal miracle that the tribunal has been created, not just out of doing this, not just to check it off, but it's a real one, and it's got teeth, and it's a victory, it's a win, and I'm grateful to all your colleagues. Thank you, Konstantin. Thank you, Sasha, dear colleagues. First of all, I'm very grateful for this invitation to be with you. I would like to thank the organizers for the International Criminal Justice Week, and that's a very good thing. That's a very good event, and it's very good that it's an event to last every year, and it's very good to have 2 days once a year and do those things with the wonderful speakers and wonderful moderators. And actually, what Konstantin says, like actually in mind with Special Tribunal being the main theme that we've been dealing with more than 3 years, we started to treat it as our own child. And really in mind with the fact that the holidays throughout the war, throughout the years of war, no nothing, no rest, and you sort of treat it as your own child, this tribunal. And we just want all those things to be made real. And there is the consciousness of doing right. There's the consciousness of doing things, what is necessary for the history of Ukraine, for international law. And if we didn't have it, that would be much worse than if we have it in this even current form. So I think that our emotions are very important indeed. And Zakhar will confirm all these things, that throughout the 3.5 years, we had quite a lot of swinging, emotional as well. I mean, very many situations as you don't have no clue what's up the band, it's easier when you do something from the inside, from the middle of the state of the country, that everything is within your competence, that you can draw the roadmaps and some deadlines, but everything when depends on you. And there are more than 40 entities like states or international organizations, then when it comes to them, sometimes ban. You cannot be sure that you can hit it. And we started our efforts on that particular issue. I'm not going to call it a project, because a project might be like something like business and technical thing, and that's its super important objective. When we started our efforts, we were absolutely sure, absolutely conscious that we might not have a result. That all these efforts, we did not understand what we're going to get to potentially. But I would like to reiterate the results that we have achieved, and you can actually open your agreement on the creation of the Special Tribunal. You may read through the statute when it comes to the agreement. Actually, the law is already effective, like 332 votes. Everyone is for it, and that pretty eloquent, speaks for itself, and you can read it through. I, for one, did not think we were going to achieve such good results, and I can't disagree with Mr. Professor. I'm sure that the tribunal can be a strong player because it's got some features, some characteristics that can actually make it even stronger than the current players on this field. In particular, of course, that concerns the proceedings in absentia, that substantial sentences potentially, what other mechanisms don't have and won't have in the near future. So this is why I'm sure that this is a very good result. If somebody has some other ideas of what could have been made better. Mykola Gnatovsky, that is going to be present at this event, and he's our teacher, and he always went like an international legal expert should be an idealist, and that's true. We've got to believe in something better, something lighter, otherwise things don't make sense. However, I'm sure that we've got to understand that we might not have come across ideal things, like what you assume needs to be done is really a good result, potentially. It's a very good win. And again, when I go over the statute again, I just cannot imagine that in 22 we assumed that was possible, and this is also possible thanks to the political will of Ukraine, political will of our international partners, because you can write all things, but unless there's a political will to implement things, there will be no result. Now, all our eyes, all our thoughts, all our job is aiming to complete this extended partial agreement job as soon as possible. That's a special tool within Europe, and the guiding committee of the Special Tribunal should be created, doing all the logistics and administrative things. Like the physically created tribunal, we need it to be like that, and we need to start the effort, start the work. And I know that I'm gonna round up. Like Konstantin's got many questions, and I will try to deal with your questions just to make the highly esteemed colleagues understand, because the top effort, the brunt, and is to conclude as soon as possible the extended partial agreement on the guiding committee of the Special Tribunal. And on our part, the Ukrainian team are doing all our best just to complete things as soon as possible, like one timeline example as to the signing of this agreement that happened 25th of June in Strasbourg. And they had previously said it could only be achieved in November, so you can just check it out. Yeah, you're gonna see it, the results, and I will try to expand it to the floor. And now we're gonna talk to each other. The first part will be the Q&A session, I will ask questions, but there will be a surprise, something unexpected. Now, the second part of it is that we got some colleagues from the International Law Academy, but they're going to be on Zoom, and they are in the Carpathians. Can you hear us? Yes, yes, we can see you. Good, great. And yes, questions For him and everybody else, we'll also ask questions. And the surprise is we're going to have an interactive session of communicating with them. And now please show the QR code on the screen on the multimeter. You can take a picture of that, scan the QR code, and then we're going to ask some questions to the audience, to the floor here, over here, and in the Carpathians. The first ones that are going to be tested by Anton, and we're going to compare then the expectations from those that are observing inside the process, outside the process, and compare it to the insider of this process, the top insider of this process, and you're going to get understanding on how much this society is expecting from the tribunal for the nearest future. And if you're interested in that kind of polling, you may take a picture of the code. Some more time. Well, right. It's going to be a very representative thing, very representative polling. Now, okay, let's wrap up here and let's get to the first question. We're going to talk about the future of the tribunal, but let's look into the past a little bit. Отже, right. This is the idea of the creation of the special tribunal that was expressed by a group of legal experts from Ukraine and abroad. March 22, this agreement was signed on the creation of the special tribunal in June. And then, as I already said, and the question is, how fast was it? You can see three options of answer that concern the audience, that concern the floor. I mean, that was signed faster than should have been expected in March 22, as soon as possible, and later, maybe later than expected, that could have been expected, and right in the time it was expected. So what do we got here? Like the majority think that the agreement was signed faster than should have been expected. What are you going to say about that, Anton? You know, there are many colleagues that work in diplomacy by much further, by much longer, and they all say as one that 3.5 years for diplomacy is just a moment in time, is just a jiffy, not a time span. You know, just to have an example, we may remember the Roman statute and how much time that had taken, and we did not have a single convention on crimes against humanity, and that was an effort that lasted for decades, and it's going to be lasting a little bit more. So I think that 3.5 years is just a lightning strike, just a jiffy, nick of time. So we can't really here think and consider the categories like within the national jurisdiction, like in a few months you're going to achieve results, and that's a slightly different area. And not everything here depends on the country, on the state. There are plenty of international partners, so it's very important that we have this political will. So I would like to support this option that it was faster than expected. And maybe my final thought, when we think about this time, we also need to think about the importance and sensitivity of this question, of this issue, because it is individual criminal responsibility of the lead country, of the country leaders and the heads of states. That's not investments, that's not trading, that's individual criminal liability. So I am sure that the first column of the results is obviously very logically making sense. I am thankful to the colleagues that do understand the situation, that it's really very, very good result. Well, as far as I can see, there's plenty of people that have chosen this later option, but just to think for myself, I did not think high of that back in 22 in March that it could have been implemented in practice, but I'm glad that it was created. So let's talk about the future of this special tribunal. And the next question will concern, like, when can you expect the completion of the process of working bodies within the tribunal formation, the formation of the working bodies within the tribunal, and 1, 2, 3, 27, year 27 is the prevalent one, is the bigger one that shows the realism of our colleagues towards this issue, and I here assume that in 26 a lot of things could be made given the circumstances allowing, but I think this kind of answer that we got on the screen is realistic, and
we try to make this progress as fast as possible, and we will try to do our best to achieve those results. If we will be able to quickly approve extended partial agreement, and when our partner states will approve it swiftly, the second column has a big chance for success. But like the third column, when we talk about the start of functioning of the tribunal, that's more realistic. Can you comment on the dynamics of establishing this working bodies? Now we achieved 2 out of 3 elements of establishing tribunal. We signed the agreement in Strasbourg. This is element number 1, because after that agreement is now considered accepted by the European Union, European Council. The second element was agreement of Ukraine for this agreement to be compulsory, and so that we did that last week. So this is the second element, and the third step is hearing the committee of the ministers' councils of an agreement to establish this tribunal. After the steering committee will approve this agreement, then European states will be joining this tribunal. Like maybe some states will automatically become part of it, some will approve it in the parliaments. So this mechanism will be different in each state. What is important, this extended partial agreement also will establish a steering committee, which will kind of establish an assembly of participating states, and they will fund activities of the tribunal. They will be caring about the administrative part of the activities of the tribunal, and this will signify the start of the work of the body. So, and all our effort is aimed at signing extended partial agreement. So if we hope to finalize this work in 2025, but if we will be successful, then the next steps will be quite fast. And let's move ahead. And my next question is about number of states that we expect to join the tribunal, because yes, we know that there was initially talk about 39 countries, and also we have a European Council, and which has 46 countries among its participants. So our question to the audience was, how many countries do you expect joining this tribunal, and we have below 30, 30 to 50, and above 50. So we see that majority of people answered with number between 30 to 50. Yes, I didn't expect there will be any answers of less than 30. Yes, but and I think this is the we see the realistic answer to this question from the audience. Yes, the core group. We still in the process of video conferences. Of course, now it's a holiday season now starting, but I want to say that we don't have holidays. We are working 24/7, and in the core group, when we had 39 countries, 2 countries. Like it started for this 41 and it was 32 because two states dropped out, and now I'm like maybe EU may also was participating, but EU is not a classical international organization yet. But let's still consider it's international organization. Out of 39 countries, these are all European Union countries except 2. Initially, one country stopped their participation and then second joined. I bet you all know the name of these countries, and I hope that all these countries that were in the core group will join the extended partial agreement and become other associate member of the steering committee, because we've seen the political will of these countries to work on that issue, and I hope the number of these countries will increase, and we will be glad if it will be more than 50. And I hope with time we will achieve that result. So agreement on establishing special tribunal is a bilateral mechanism between Ukraine and European Council. But option of multilaterality is very important for that. So to accept to on board more and more countries, so we will be welcoming new members. But it's very unlikely that all countries of European Council will join. Yet I don't think that will happen, but maybe it's not a compulsory thing. For the Secretary General of European Council to be able to sign an agreement on establishing tribunal starting from June 25th, he was supposed to have authorization for that by 2/3 of the members, and the minimum number of states to vote for was 30, but an actual number of votes was 40. So 3 countries voted against, 2 countries abstained. We understood that not all countries of European Council will support this tribunal, but that was enough of supporting votes. And even not all countries will support this tribunal will be functioning, and extended partial agreement is open to any country globally. The country cannot participate in any previous activities, but if they will want to join, the doors are open for such country through the mechanism of extended partial agreement. Next question: when we can expect a first conviction by the prosecutor of special tribunal? So, and we had a couple of numbers: year 26, 27, 28. Yes. So we see that year 28 is got more votes. Someone believes 27, and someone is very optimistic and believes that it can happen in 2026. So, Mr. Anton, please comment the results of answers of the audience. Colleagues with whom we communicated on that issue, they know that issue of time deadlines is not easy to comment, because a lot of things depend not only on Ukraine. When the steering committee will be functional, when they will appoint the prosecutor, I wouldn't deliberate on that much. The results we see on the graph, this is like normal normal forecast. We cannot be very more precise now at this moment, because to understand when the prosecutor will be able to do convictions, we have to understand when they will have office, when the judges to the tribunal will be appointed. Too many factors had to variant variables existing to give an answer to that question. So I would think that the answers there more or less reflecting the reality. So like so we expect that by 2027 the working bodies of the tribunal will be already established, and that's from that time onwards we can expect the convictions from the prosecutor. Next question was how many people will be convicted by this special tribunal. So we give three variants: less than 20%, around 20%, more than 20%. It's difficult to answer to this question. It will be a matter of this matter of decision by the judges of the special tribunal, and we always spoke when we were advising with colleagues from the prosecutor's office about number of around 20 people. Like, will it be below 20 or about 20? Yes, that's a rough estimation. Maybe it will be these permanent members of the Security Council of Russia who voted for aggression. The composition of that Security Council is more or less stable. I think that approximately 20 people, tribunal will be not able to prosecute more people, and I don't think it will be necessary. They should concentrate on prosecution of the top political military leadership of Russian Federation. Can there be possibility that this will be not only top leadership of not only Russia? Yeah, like, because we call it this special. We don't mention this is tribunal on aggression against Ukraine without mentioning any particular country that was aggression. So this can be anyone. This can be also leadership of other countries, not only Russian Federation. I see a possibility of adding leadership of another two countries. But yes, so legally, special tribunal is not limited only by leadership of Russian Federation. And my last question to Anton is when we can expect the first conviction by the special tribunal. So we had two variants, 28, 29, 28, 29, 29, 30. Also, answers quite realistic. That would be a great result to have convictions by that time. That's it from my side. I want to add that just to summarize that our audience who are present in this room, they are very well acquainted with the topic international criminal law, and they are on the same page with your colleagues, and we can see that your activities has great support and understanding among the experts. And now I pass the floor to the colleagues from the third summer School of Law, and they have options to ask questions to Mr. Anton. Thank you for. My name is Vitaly. My question to Anton, I have a lot of them, but I will start. So my question was about the place where the tribunal will be located, and we have an example of Special Tribunal on Lebanon, but that's the question I was going to ask. Yes, but I wanted to ask about the provisions of the charter that acting head of the Russian state is not the idea of having tribunal on the crime of aggression. It implies that the top leader of Russian Federation had to be prosecuted, but somehow it's not depicted in the charter. So thank you to Vitaly. I'm very glad to see my colleagues who are now in Transcarpathians. I envy. Sorry, I'm not able to be with you, but great team collected there. That's to answer your question. I started with that with the notion that we all want to achieve ideal result, and I think that's the right thing to do, to aim for ideal variant. But we had to end with such draft of charter of the Special Tribunal that can be accepted by all partners who support art with this initiative. When all can consider that this was acceptable result for the current situation. Of course, from the very beginning, we mentioned that there should be no immunities. That was our state position and the position of many other states. Unfortunately, some other partner countries, key partner countries, had different position. For example, G7 countries. And that's why we had to end up with the compromise that would be accepted for everyone, or just to stop that process. And that's why, in particular, we ended up with a very good variant. Again, I would assess it as a certain package proposal, a package deal. What does it mean? It means that, number one, with regards to personal immunities, zero words about personal immunities is mentioned in the charter of the tribunal. That was our position of Ukrainian state. In the material part of the statute, there are zero notions that someone might have any personal immunities. In the procedural part of the charter, yes, indeed, it is said that when we are talking the top three leaders, the prosecutor might investigate the case. The prosecutor can do indictment, can publicly present it to the judges of the Special Tribunal, and when this will be a matter of the top three leadership until they are in their position. As soon these top three leaders are released from their positions, then the case will be continued. This is the compromise that we were able achieved, and that to proceed with establishing this tribunal, and it was acceptable by all core group members. But I would also compare it to two other provisions. And that there is a provision that Special Tribunal doesn't recognize any functional immunities. And those who knows who is involved in issues of international criminal law, they know that how many fights are going in terms of applying personal sanctions. Yeah, some country can be selective in terms to whom apply these sanctions or not. And there is so because there are legislation passed on the immunity of foreign officials from criminal prosecutions, that some countries believe that immunity extends to all officials of the state, not top 3 officials. And the matter that we entered provision on that no functional immunities will be applicable to the activities of this tribunal, and the third one is the independence of the body, because and this tribunal will be the only mechanism that will be to prosecute this leadership. Because what we have now, we have orders for arrest, but order for arrest, it means that you are suspected and there is allegation against you. You are alleged a criminal because there is no yet conviction. But this tribunal can go further, and the process can end up with conviction and confirmation that person is a criminal. So the issues on this top 3 leadership, I would talk about it in terms of not the activities of the tribunal is not recognizing any factional indemnities, and that it's and that it will be able to do indictments. And from the opinion that and of the general public in Ukraine, I see that people in Ukraine understand these realities. Yes, because I can guarantee that any ideal best lawyer in the world wouldn't be able to achieve the better deal on the tribunal and better draft this charter of tribunal than we did. So that was the reality we were able to implement. Greetings. My question is about whether we will go further with compromises, and whether aggressor country will be able to use this tribunal by diminishing the international law, that when they will require that cancellation of liquidation of this tribunal will be a prerequisite for start of the peace talks, and that might block the activities of the tribunal, because it kind of be threat for the top leadership of, and that's what will be the reason they will reject to be involved in peace talks. I'm in charge of international law, and I'm not involved in peace talks. I cannot comment that issue, and because this is not my mandate, not my sphere of competencies. From what I see the political will of Ukraine, which was expressed in very fast signing of the agreement, ratification by the parliament of this agreement, and ratification of this tribunal with constitutional majority. I see that our MPs did all they could do to expedite this process. From the legal point of view, I don't understand how you can reverse this process, because the agreement is already ratified and signed. I hope that nothing of that kind will happen. And many of our partners, they say that there is a track of achieving peace on the combat field, and there is a track of responsibility.
And I have a lot of in common with this position. It's an adequate position, so regardless of what it's going to be, other different people are working and they're actually moving ahead. Anton, and I will afford one more question to be very straight, but the Special Tribunal statute doesn't have a mechanism, the one that was in the Roman statute, that the Security Council may request. It was like to block and suspend any investigations of the International Criminal Court, like, and they have to obey, but the tribunal statute doesn't have that mechanism. That's right, because you might you will have to be not responsive but proactive, and that is the what the tribunal effort stands for. Any more questions? Anton, good afternoon. Good morning. From the academy's fields, my question is about the crime of aggression, and is the crime base or the corpus of the crime is the same? And then the second question, can other international crimes be regarded by this tribunal in future as a confirmation of the availability of the corpus of the crime of aggression? Thank you, Mr. Manuel. Yes, we can open the statute and see Article 2. And the first question was threesome, and the second one was the definition, because, as you know, the Kampala amendments are not sustained by all the countries. Many of them just criticize and they don't want their application in wherever and whenever. This is why we have a very interesting working option. But the 8 base, the Kampala, that's the definition of crime. But it is completed, complemented with one more threshold before Kampala, the threshold, Kampala threshold, and also plus aggressive war that stands from Nuremberg. And the last element was a standalone requirement of many countries. You need to understand, and we as the country that support Kampala, they decided that that decision was absolutely all right, because it was based on Kampala, did not contravene Kampala. So this evaluation is very important, and for future the creation of this tribunal and its work down this path does not get in the way of Kampala and Kampala's future. So I think here we have preserved the value, this important value that is very important for our international partners. And something more, a little bit about Kampala. We saw the urges of many multinational organizations to support Kampala too, so we are supporting it. We're not just posting about that on Facebook, because we're a principle based state that has its position. We understand our responsibility, political responsibility, legal responsibility. We have an understanding of how much important it is not to allow a thought of double standards. That we're in New York, we officially supported Kampala too, and 2 times we had very strong presentations to support Kampala too. And the second presentation was completed by saying that Ukraine is going to conduct on this policy, and we relate this issue to the top governance, about Kampala to support. And thank you for that kind of address. Thank you for that kind of effort, and the team is working, even if there is no space for the likes. In New York, I think that what happened had to happen. We had it coming. They're not ready to move ahead within Kampala too, but the work is going on. And in 2029, they're going to revert to the same issue. I'm going to get back now, but nobody is questioning the definition, right? So this is why, just to finish the phrase that the Special Tribunal does not pose a threat to the unity and of international criminal rights law when it comes to crimes. Okay, I will make my contribution. If you understand that all these procedures will be completed and all the statutory documents will become effective, so many countries are going to join in, then the provisions of the Special Tribunal on for the crime of aggression, it is the crime of aggression. Does it exist in the Nuremberg form or Kampala form? What would you think? I think that's the Kampala form, because from Nuremberg there is another additional threshold of aggressive war, but the definition's basis is Kampala, and act of aggression is the threshold. So I think here, and again, that kind of definition, it was sort of sealed by those that promote like strengthening the jurisdiction. For example, Liechtenstein, Luxembourg, Germany, Belgium, and so on and so forth. So for them, that is Kampala, and that's additional complementary thresholds of aggressive war does not get in our way, in their way. So I think that's first and foremost is Kampala. Dear colleagues, if you have any more questions, we're ready to take them. I've got a 1.5 question right away. First of all, do you have an idea about where the tribunal will be seated, like the physical location, because it's very important, and we see it on the example of the other tribunals. And another question is more interesting, actually. Why did they decide to be only restricted by the crime of aggression? Because we can see and that the possibility of a session in absentia, that's International Criminal Court. It does not contravene, because that's the only way to punish the perpetrators, the top perpetrator, what perpetrators. Why did they refuse this concept? Thank you, Mr. Professor. Thank you, Mr. Vladimir. But the location, we would like it to be, we want it to be the Netherlands. The Hague and the Netherlands are politically ready, as they say, and there is some closed efforts, confidential efforts. Everybody is really snowed under, and when we are ready to publicly announce things, we will be ready. And I think there are no other options for location that are thought of, and there has to be a lot of internal efforts to make all this possible. And the second question, of course, no other mechanisms except for that can try people in absentia when it comes to Ukraine's situation. But I think that the question why only the crime of aggression is pretty obvious, because International Criminal Court might take on any other cases, and I'm sure that our international partners would not be supportive of us if we were creating some sort of parallel jurisdiction that can try people for the same crimes as the ISS can do. And I'm sure, you know, that would not have been possible, but otherwise we just took this niche, this gap that is pretty much outright to our international partners. So Ukraine's ambition to create exactly the tribunal for the crime of aggression was supported, as you can see, in this current form by a great part of international community. Not big one, but a major one, not the most one. If you have any questions, and I'm going to talk to the Carpathian colleagues. If you have questions, I think you will understand us, because that will be your last question maybe, and we're short of time. We have one more from this floor. I really can't see any more questions from here, so we want to thank you first of all for getting connected to you. for the possibility to make our points and ask our questions and listen to Anton, the highly esteemed Anton, and his presentations and his answers were very much informative, and they were kind of including answers to many other important questions, which are, was very important to us because there is the judicial component, there's the international humanitarian law, and ICC component, and those additions of complementations that we have heard was very much to the point, was very relevant. Thank you very much for connecting for us. Connecting us and for Anton's fantastic answers to about the tribunal, and we hope that it's not going to be 2030 for the first sentence, but once it's going to be even in 30, it's going to be really, it's going to be fair. Maybe earlier. Thank you, dear colleagues. Thank you for your interesting questions. And now I want to ask the floor. Volodymyr Yavorsky has a question for Anton. Thank you. I maybe missed that in the very beginning because I was late in the very beginning, but what I want to ask is why doesn't the statute has anything about victims? I know about survivors, victims. I know that's a very complex legal issue, but international organizations keep asking us what we're thinking about that, and in general, how the situation will unfold and on this account, because that's a great stint, and it sort of looks ignored. Thank you for the question, Mr. Volodymyr. Here, you know, that the issue of victims, that's an issue with different positions of different countries that you would never think anything different, like not those that are sticklers for ideals, but even other ones. Even the most progressive, advanced international legal experts thought that the crime of aggression is that against all the country, all the people. How are you going to single a single victim out? How do you single out what's got to, who's got to represent all those victims and survivors? Why that particular, not that particular? Because the crime of aggression is committed against everybody. So that's the difference between the atrocity crime, because war crime is against an individual or their property, but something like a crime against humanity. But here is the object, is all the, or subject is all the country, the sovereignty and territorial sovereignty, all Ukraine. So there was serious discussion, and we finally connected to that option. That's according to Article 22, if I remember it right. What we are reading in it, it looks pretty not bad, like in the context of crime of aggression, because there was full absence of previous practice. So that's a terra incognita, terra nullius. No practice, and everyone like had the same thought that was the same formula according to which they can live. Yes, many countries said there could be victims. Many said there could not be, that there can't be. Yeah, even progressive ones, advanced ones. So I can't disagree. That's an issue, but what we already got there is already good, and representativeness of the victims groups, of the survivors group, is already good. Thanks for crime of aggression. And I can also talk about one more thing from the additional excerpts, and we're still working. And it seems to me that that provision has nothing like, you know, it's like the civilian legality, legal ability of an international organization. They have to make an agreement for witness protection, or for some labor agreement, or opening up a field office in Ukraine. So we don't see as the key point that's an entity of international law, and that it's got a successor, also succession, like they're going to conclude contracts for water supply, for the internet, and you know, in Ukraine, I understand your concern. like crime against Ukraine. There can't be an ideal answer to that situation, but I here assume if you look at those provisions in the context of civilian legality, legal succession, I don't think there could be any issues, but there could not be ideal answers.
Доброго дня, Руслан Синельник, голова Заводського суду Запоріжжя.
Ruslan Sinelnik, Zaporizhzhia, one question and a half. The first question I would like to ask you right away, what is your opinion about the possibility of pressing charges for abducting Ukrainian children? That's just my legal thought as that of an international legal advisor. And the second question, that from the previous one, actually, what do you think about the possibility of practical implementation of local court decisions, of Ukrainian court decisions in local conditions for moral damage compensation to the state of Russia, that the position of the Supreme Court, immunity could be in the course of aggression? So what do you think? How could it be made practical? Is it related to the tribunal's activity? And
Thank you for your question. To the first part of your questions, our special tribunal will judge only of the crime of aggression. Yes, children are very important topic for us, but will be responsibility of ICC, and but it also judges can put any elements into their decisions in terms of how this aggression how showed itself, because in the reasoning part, judges can put that in the context of the Russian aggressions, these were crimes that committed, and the most so. But with regards to prosecuting cases of deportation of children, the ICC will be more in charge of that. But if the Ukrainian judicial system believes that's important to do, that's the second part of the questions. I'm not working in the courts. I don't see the prospects of implementing those decisions at international level. That's how I can answer to your second question. And let's hear another question from this part of the audience. I want to go back to the issue of the victims. As a legal counsel, I'm representing a number of self-government authority that are and working in the interest of local communities. My question is, how victims of the crime of aggressions, how do we count them? Can the territorial communities be considered victim of the crime of aggression because they suffered systematic impact of aggression? For example, Bucha district of Kyiv Oblast, there are a lot of communities who suffered comprehensively. Yeah, there are some citizens who suffered from war crimes, but there are also signs of crime of aggressions. I have to apologize. That will be the last question to be answered because I had to go back to the office. There are some urgent issues to attend. As I mentioned already, there is opportunity for testifying by witnesses or by victims. Yes, can community victims as possible? It will all depend how court will on the decision of the judges.